Hello. It is now 10:15 on Thursday, May 23rd, 2019. We are here for a public hearing, an opportunity to comment on proposed amendments to the New York City Health Code Articles 11, 71, and 173. My name is Sherry Anhouse. I'm Associate General Counsel in the Office of General Counsel for the New York City Department of Health and Mental Hygiene. With me is Chris DeAndrea, who is Assistant Commissioner for the Bureau of Environmental Disease and Injury Prevention in the Division of Environmental Health. We are here to have a hearing on these amendments, which were which were approved by the Board of Health for public hearing at their meeting on April 17th. This proposal was published in the New York City Record on April 23rd, both in 2019. We have one person pre-arranged to pre-signed up to testify, who I don't see here today. We have one additional person who has come to testify. I'm going to ask him to come forward and state his name for the record and give his comments. And if you have a written copy of the comments, that would be great to get them, please.
I have multiple copies. Should I hand them up?
You could just, I'll just take one or two. Okay. Please state your name for the record.
My name is Matthew Chachere, Chachere. I am an attorney with Northern Manhattan Improvement Corporation Legal Services at 45 Wadsworth Avenue, New York, New York. We are also counsel to the New York City Coalition on Lead Poisoning, or NYCHealth. I'm going to summarize, since there's a 3-minute time limit here, although I don't think it's going to run that long, the longer comments which I've prepared in writing, which have a number of exhibits to them.
Just for the record, I have received a copy in writing of the comments from Mr. Chachere.
And while we commend the board for most aspects of this proposal to tighten the, lowering the level of blood lead that will trigger mandatory enforcement by the health department, we think these changes bring up a critical issue which we've raised in the past and which we think the board should seriously reconsider. And this is the changes in 173.13 D2 concerning the mandatory abatement, inspection and abatement when you have a child with a blood of 5 micrograms per deciliter or greater. In the proposed amendment, the mandate would be an inspection of lead-based paint hazards and the abatement of lead-based paint hazards because of its condition, location, or accessibility to children. And our concern, given the unfortunately long history of lead poisoning in New York City, is that this is not sufficiently protective. And just somewhat of a short history here. As you may know, decades ago, the wording of 173.13 D2 on its face actually required the complete abatement of virtually every surface in a dwelling where a child was in the age where a child had an EDL, which at that point was 20 micrograms. This was in fact the mandate of the city law at that time, Local Law 1 of 1982, which required full abatement of all surfaces in any dwelling where a child was residing, even if that child did not have an elevated blood lead level. And in fact, because of this mandate, when the Board of Health back in 1996 attempted to change this mandate to just peeling paint, the coalition successfully sued to enjoin the Board of Health from doing this for 2 reasons. First, we argued to the court that amending the health code to render these measures for prevention of further lead poisoning to be weaker than what the administrative code enacted by the City Council mandated was not legally defensible. And while we averred that the board certainly had the power to make the health code more protective of children, they couldn't make it less so. Secondly, our contention was that as a matter of public health policy, it didn't make sense to do less than full abatement in a home once a landlord had effectively demonstrated itself to be so negligent as to cause the poisoning of a child. And in one of the affidavits we submitted in support of our litigation, the late Dr. John F. Rosen of Montefiore Medical Center, one of the nation's leading experts in childhood lead poisoning, explained that, quote, "It doesn't take a major event such as a water leak or a hole in a wall to release more lead paint into the environment of a child's dwelling. All it takes is a nail being driven into the wall to hang a picture, a bike or a tricycle banging a wall, beds being moved, and normal wear and tear, particularly where young children reside. Full inspection and abatement of all lead paint is especially necessary in the home of a poisoned child because the very fact that a child was poisoned is an indication that the landlord has not been able to prevent the child from being exposed to lead paint and dust in the past. There is thus no assurance that the landlord will be able to prevent re-exposure in the future unless all lead paint is abated, not just the paint that's presently peeling. We shouldn't be playing Russian roulette with the health of these already poisoned children," end quote. We also submitted back in 1996 a very tragic story in an affidavit by a woman named Deborah Battle, who illustrated the dire consequences of less than full abatement ordered by DOH. And to summarize, as she explained, 4 times she had a child. That child became lead poisoned. The health department went into her apartment, ordered a partial abatement of presently peeling lead paint, then told her the apartment was safe. Then she had another child, and then that child became poisoned. And then they did another partial abatement, and this happened 4 times, 4 different children. And by the way, the landlord of her apartment was the city of New York. And this isn't a new issue. I mean, in 1969, and I attach an excerpt of it, there was an actual lead issue study issued by the health department, December 15, 1969, which raised this very question. It said, there has been, quote, "There has been no attempt to estimate the number of repoisonings that have occurred in units where painting and plastering have been performed, i.e. the violations have been complied with. There has been no attempt to estimate the number of units that showed further or new deterioration after a short period of time after the landlord has complied with health department rules." Now, in 2004, the City Council enacted what's now known as Local Law 1 of 2004, which was a major restructuring of the city's approach to ending lead poisoning. While it no longer required total abatement as a primary prevention measure, it offset that by a series of mandates on landlords in the city. First, it imposed a continuing duty on landlords to eliminate all lead-based paint hazards in any dwelling where a child under the age of 6 resided, and define lead-based paint hazards very broadly to mean any condition that could cause a child to ingest lead. In order to effectuate that duty, Local Law 1 imposed a mandate on owners to inspect those rental units where children under 6 reside at least annually and more often as needed for lead-based paint hazards, to document that in writing and to safely correct it on pain of prosecution for a misdemeanor punishable by up to 6 months in jail. It also mandated the permanent abatement of lead-based paint on friction surfaces once the apartment became vacant. As a result of those changes, the Board of Health was able to amend 173D2 so it no longer, at least facially, required full inspection and abatements once children became lead poisoned. But unfortunately, the goal of Local Law 1, which is to end lead poisoning by 2010, has not been met. In fact, since 2010, the health department has identified well over 60,000 children with blood lead levels over 5 micrograms. It submitted that this unfortunate statistic is, at least in part, a consequence of the failure of the city to fully enforce the provisions of Local Law 1. In the 15 years since Local Law 1 went into effect, the city has done absolutely zero enforcement of the requirement of landlord self-inspections, not once. Nor has it done any enforcement of the requirements for vacancy abatements. And given the failure of the administration to take any action to to make private landlords regularly inspect for lead hazards and abated vacancy, the assumption that the most negligent of landlords, those who have already poisoned a child, will do so after a commissioner's order to abate, that may require some of the lead paint to be abated, but leave other lead-painted surfaces behind, we contend is fundamentally fraud. If the response of the health department in the instance of the most irresponsible landlords is effectively no different than that supposedly taken by HPD as a prevention measure, then the laws will continue to fail to prevent lead poisoning. And this is not a hypothetical that I'm throwing out there. In a case we recently handled in my office with a family named Kiran Dumbai, who moved into their apartment in 2005 in Washington Heights, an apartment that should have had all friction surfaces abated. The child, Axel, was poisoned in 2016. The health department inspected, found 19 locations with lead-based paint, 7 of which were on friction surfaces that should have been abated at vacancy. The city did nothing about the fact that there was obvious indications that the landlord had violated the law and not done the friction surfaces at vacancy. After the apartment was abated and cleared by the health department, the family resumed occupancy in 2017, and again in the summer of 2018, Axel was again found to have an elevated blood level of 13 micrograms. The health department did another inspection and again found lead-based paint hazards, and HPD found more lead on other friction surfaces, all of which should have been abated at vacancy, should have been abated 2 years prior when the health department was in. And again, the city took no action to enforce these obvious patent violations of the requirements of abating lead painted on friction surfaces and the failure to do annual inspections. The apartment was cleared by the city again earlier this year. However, just last week, HPD was in the same apartment and found more peeling lead paint. So this is, again, not a hypothetical. This is the same problem that Ms. Battle was facing in the 1980s, and this is the same problem the health department identified back in 1969. So logically, it would seem to make no sense that when responding to an EPL child, for the health department, at minimum, to not do a complete XRF inspection of every single surface. So at least we understand where the lead paint is. And we would submit that unless there's empirical data to the contrary indicating a lesser response is sufficiently protective, that the Board of Health should strongly consider mandating in the instances of a rental dwelling with an EBL child that all surfaces with lead-based paint be permanently abated. A landlord's demonstrated inability to carry out its obligations to prevent the lead poisoning should operate to deny the landlord an opportunity to poison that child again. Thank you.
Thank you, Mr. Shashir. There's nobody else here to testify. It is now 10:30. We will wait until we will stay here for another 15-20 minutes, and somebody did sign up to testify, and we'll come back then. Thank you. Time is now 10:45. Nobody else has come to testify. We're going to adjourn until 10 minutes of 12 and come back to see if anybody has come to testify. Thank you. You sit right there. It is now, ready? It is now 11:32. We are back on the record. Christine Appa is here to testify. Ms. Appa, could you please say your name and your affiliation and spell your name for the court report? Sorry, the stenographer, we're not in court.
Hi, my name is Christine Appa. I'm a senior staff attorney at New York Lawyers for Public Interest, where I serve in the Environmental Justice Program. My name is spelled C-H-R-I-S-T-I-N-E. My last name is A-P-P-A-H.
Just keep your voice up.
Sure.
Is the microphone on?
Thank you so much for having this opportunity to offer testimony in support of the regulations that we recently proposed. As I mentioned, my name is Christina, and I'm a senior staff attorney at New York Lawyers for the Public Interest. New York Lawyers for the Public Interest was founded about 40 years ago in the service of the community. We have 3 program areas: environmental justice, health justice, and disability justice. All of our program areas work together to address issues that are of critical importance to New Yorkers, particularly New Yorkers living on limited means, lower income. A lot of my work is dedicated to children's environmental health, so I'm here to testify in support of the regulations that have been proposed. A considerable amount of our work in environmental justice is dedicated to ending childhood lead poisoning. We've been actively involved in efforts to reduce the amount of lead and eliminate the lead in school water, drinking water, in housing, and particularly in lower income housing. We recently released a study in September of 2018 titled Lead Loopholes, where we discussed the importance of enforcing Local Law 1 of 2004 and all of its provisions in order to alleviate the problem of lead poisoning in housing, especially rental housing. The regulations proposed in Article 1171 and 173 are taken together. We believe that they'll offer great support to the recently passed legislation of the City Council, which we worked hand in hand with our community coalition to get passed. I want to make some comments on some parts of the legislation, but I'm also submitting comments, written comments today. We support Article 11's prompt notification provision and believe that we should continue to offer ongoing support to families that have received news that their child has elevated blood level. I want to make a particular point about privacy concerns for the blood level registry. I think that given that there can be a stigma attached to the condition of being lead affected, we don't always want to call it lead poison as it affects people differently. We want to make sure that the information is kept in utmost privacy and that the information is sufficiently anonymized so that way people aren't able to access the information, and if later on in life the child grows up, it doesn't always have to be associated with this information. Upon some research, I also discovered that Massachusetts has a similar provision, and they're recently updated lead prevention. Also, for Article 71, they're directed at assisting people to steer away and to avoid purchasing products that may be lead contaminated. We also believe it's very important to inform retailers as well as consumers, but also healthcare providers should also be part of this, as well as religious and community leaders continue to support that. Article 173, I want to make a particular point that I list in my testimony, my written testimony. There's a particular provision that's stated not for food use. When people are using plates or dishes or anything like that, that might be glazed with any contaminant that might have some lead in it. One of the provisions just says not for food use, and I don't believe that sufficiently explains the risk to the person, to the customer, and that of the 3 provisions that are listed, that one is the weakest and should most likely be removed. Another consideration is that the regulatory amendments suggest that all of the notifications should be made in English, and we're a very diverse and multicultural city. So in order to make it as effective as possible, I propose that we use, in addition to the English notification, we can create maybe some pictograms akin to the OSHA standards that they use, like these different pictograms to denote, like this is toxic because, or how it would affect somebody. But if we in New York City, we have such a great and robust graphic design public information department, I think using some key symbols that, maybe something from the periodic table of elements showing that this is lead, that, ingesting this would be dangerous to your health, and then something else of the sort, like not for children. If we can use this as like a universal symbol that we're using just within our city, and then take the opportunity to use our language access, our ability to translate it and interpret it in different languages, but that everyone will be able to universally recognize it, akin to washing instructions on clothing and apparel that's used around the world. There are some university accepted and acknowledged symbols. So I think that might be a good way. Another point I'd like to make is that the Article 173 amendment discussing embargoes, we should also have some provisions in there for how we're going to deal with online distributors who may not consider themselves retailers, or people who may be distributing or giving out these items for free. There should be also some provision for how we'll deal with online, how online sales or any sort of online commerce. I think it'd be very important to make a notification about that. And then finally, when it comes to the hazards of unsafe paint or unsafe paint, lead paint hazards, I just want to reiterate a point that we've been making for several years as advocates, that while paint that is peeling, of course, is the biggest proxy for proximate danger, we just want to make sure that we do it in the most efficient way, because paint that's not peeling today will likely peel tomorrow or maybe 10 years from now. So if landlords are incentivized and encouraged to complete total abatements as a primary means of preventing lead poisoning, I think this would be much more effective than the gradual process of, I see this peeling paint here, I'll take care of it. But the concern is, when the next family moves in and then there's further wear and tear, will the landlord come back? Total abatement once would be much more effective. And then finally, and most importantly, to continue to enforce all the provisions of local law 1. It's one of the strongest and most detailed lead poisoning prevention laws in the country. It's that FACTA model, and we encourage the city to continue to work with all the other branches to ensure that we don't have another generation of children affected with lead. Thank you.
Thank you very much, Ms. Zappa. Are you done? We're going to stand adjourned for another 10 minutes, and if nobody else comes, we're going to adjourn for good.
Thank you so much.
It is 12 o'clock noon. No one else has come forward to testify. I am closing this hearing. Thank you very much.